Let's begin. Welcome everyone to the morning session, OPRA today and tomorrow, the 17th annual OPRA seminar. Most of you by now, I think, know me. However, I will reintroduce myself just in case. I am Frank Caruso, the Executive Director for the Government Records Council. I've been with the GRC now for 18 years, going on 19 years in February. And it's a pleasure to be here today. We've been doing this seminar for a number of years for both members of the public as well as government officials, employees, and so on throughout the state now for technically it's our 17th year. We did miss a few years during COVID, as most people did, but we're happy to again provide this seminar today for your enjoyment. I will begin where I always begin. Most of you who have been in a training with me have seen this statement made repeatedly, and that is effectively that everything that you're going to hear today is educational and for informational purposes only. It should not be construed as legal advice. This should also not be construed as a decision of the council, the Government Records Council, our body that makes the decisions on a monthly basis. If you are seeking legal advice, then your best bet is to contact your legal counsel, whoever you have contracted with, or whoever you are assigned to in legal over in your various divisions, departments, so on and so forth, or to contact an attorney if you're a member of the citizenry in order to obtain legal advice. Contact information. So this goes a little bit toward what I was saying earlier in terms of CLE and CEU certificate for today's event. And I will note at this point that for the first time ever in the agency's history, we have 1,000 attendees expected to join today. That number, 1,000 individuals expected to join today. So you'll definitely want to make sure you know this email address, especially government.records@dca.nj.gov. This is how you get in touch with us, generally for questions about anything involving OPRA, the Open Public Records Act. You can send us an email, you can call us, you can fax us. You can go to our website where we have many resources, which I'll talk about in a little bit. But we'll have a lot of folks today, and that's great because you can get a hold of this contact information, save it, and have it for your needs. If you are contacting the GRC because you have a question about the Open Public Records Act or about a request that you're working on for our custodians here, or if you're contemplating the filing of a complaint, if you're a part of the citizenry, please note that it usually takes us 24 to 48 hours to get back to you. We are a considerably small staff of 6 individuals, and therefore, it takes a little bit, usually 24 to 48 hours. So you don't want to wait until the very last minute to try and get in contact with us, because if you do, there's a chance that you may miss deadlines, whether they're response deadlines, whether they are complaint filing deadlines. You may miss them if you get to us on the last day or at the last minute, and it takes us a little bit to get back to you. So important contact information here. This is how you get a hold of us if you do have those questions that are plaguing you on a daily basis. All right, so everyone's here because I'm sure you all know at this point what OPRA is. But very briefly, back in 2002, OPRA replaced the old right to know law and fundamentally expanded the definition of a public record. Under the old right to know law, that definition used to be any record required by law to be made or maintained. That may sound familiar because part of that definition exists today in the criminal investigatory exemption. However, OPRA's general definition for a government record is now any record made, maintained, received, or kept on file. So OPRA effectively created a very broad-based definition that expanded access to what could be available when someone submitted an OPRA request. I guess at this point, almost 19 years in, I'm thankful to say that OPRA also created the Government Records Council. Back in 2002, I was going into my junior year of college. that summer. So I knew nothing about OPRA. I knew nothing about the GRC almost until the day I showed up here all those years ago. But I guess I can say I'm happy that we're here now. So OPRA also authorizes the complaint process. I'm sure many of you who are on today are familiar with the denial of access complaint process through the GRC, but also that ability to file a complaint in court with your county court if you wanted to challenge a denial of access. So what we typically do, first and foremost, is we adjudicate denial of access complaints. As part of that, we administer a voluntary informal mediation program. That program is confidential, or that program, any of the communications therein and the discussions held therein between the parties and our mediator are confidential. The Uniform Mediation Act, as well as the GRC's regulations, require a strong sense of confidentiality be kept in what goes on in mediation. We operate our hotline and our general inbox for inquiries, contact information of what you just saw. We operate our website, inclusive of extensive informational materials, manuals, FAQs, and all past decisions. Some of those include presentations, past presentations, and I'll note, I did put it in the chat, but I'll note that all of the presentations you'll see today will be posted to the website at the conclusion of today's event. We have our Custodian's Handbook, our Citizen's Guide to OPRA, FAQs that are pertinent to both requesters and custodians. We have all of our past council decisions on there in a searchable prior decisions database. We have copies of all of our vital documents, so the denial of access complaint, amended complaint, request for reconsideration form, statement of information form. We have our regulations right on our homepage. We have important announcements that we put under what's new right on our homepage. So a lot of stuff going on that website that could be helpful to any of our attendees today or anyone who's interested in the Open Public Records Act. And of course, we provide OPRA training, much like we're doing today. So I'm sure everyone's tired of hearing me say this, but I make it a highlight right at the front of every one of my presentations. And that is, way back in 2002, when OPRA replaced the old right to know law, it did not become the only records process available to an individual in the state of New Jersey. OPRA applies to those requests where the requester chooses to invoke the statute, meaning the requester submits an OPRA request. That's when OPRA begins to apply. Now, presently, under the new version of the statute, it pretty much states that the request should still be on the official form. However, now it's codified the use of the form is not mandatory. That basically means that an individual still has the option of submitting an OPRA request and not on the agency's official OPRA request form. And we'll get into what the parameters of that written equivalent are going to look like. However, OPRA is not going to apply to anything that doesn't start with an OPRA request. For custodians, one mistake that they'll often make is they'll get a generic request, an informal request in a letter. They'll treat it as an OPRA request. If it doesn't invoke OPRA, if it's not on the form, or if it's not in the proper form for a written equivalent, it is not an OPRA request and OPRA is not going to apply. So what are the other ways to request records? Well, first and foremost, my most favorite, the administrative or informal request. The individual who comes into the municipal clerk's office and asks for a copy of minutes. The person who recently had a car accident, who's come to the police counter looking for a copy of their accident report. An individual who wants to discuss their property taxes with the tax assessor. An individual who would like to build an addition on their property, on their home, and they're looking for their building plans, or they want to see copies of past permits because they're concerned that something might not have been done right. These types of requests still should be honored, still exist, and are still available. One of my common questions to some of our older guard custodians who were around before OPRA went into effect, and they would call and say, so-and-so is asking for this record. Do they have to file an OPRA request? My question back to them, I know it can be kind of rude sometimes to do that, but my question back to them would be, well, what would you have done before OPRA? And they would often say, well, I would just give it to them. So, well, there's nothing stopping that from happening now just because OPRA exists. Again, it's only one process. Administrative and informal requests are still a regular part of the everyday business. Common law requests. You'll most often see common law requests paired with OPRA requests, but the common law is a separate process from OPRA. The basic threshold for disclosure under common law is, does the requester need it more than the agency needs to keep it confidential? It's a very different threshold for disclosure than under OPRA, which is it's a government record and it's disclosable unless it's exempt under one of the exemptions. Discovery requests. This has long been a big hangup as it relates to people involved in litigation who are turning around and filing OPRA requests with the agency, or vice versa, who are filing discovery requests with the agency and may be pushed toward OPRA. Discovery, court process, separate from OPRA. And then we have our other court processes, subpoenas, court orders, so on and so forth. And I will note, to all of these other types of processes, the governor signed into law, I believe, last year, an amendment to a statute that basically now says that victims of a crime shall not be required to file an OPRA request to obtain access to records regarding their victimization. That's a very important thing for everyone to know and understand. If you have someone who has been identified as the victim of a crime and they come in looking for access to records related to that crime, there is a state statute that now says that they are not required to file an OPRA request and they shall not be made to file an OPRA request. So for any of our agencies out here who have a policy by which they're requiring everyone to file an OPRA request, know that there is a statute that says, as it relates to crime victims, you can't make them file an OPRA request. This is important, an important distinction in understanding all these other processes that are here that exist, and the fact that a mandatory OPRA request process probably isn't the best idea. The other thing I tend to note nowadays is that every one of these request types, every time a requester comes in and tries to utilize one of these other processes and is pushed toward an OPRA request, that agency is giving themselves another chance at the potential for litigation on the back end if they have to deny access. And here's the other thing for requesters. I'm sure some of our requesters who may be in attendance today can probably say this. There is a level of frustration that goes on when people are told to file an OPRA request, especially in a situation where they believe the record is fairly innocuous, something like building plans, something like a tax bill, something like an accident report. And they're being told to file an OPRA request, and the expectation is, well, if I just file this paper, I'll get it. And then they get denied. And then there's a level of confusion and sometimes anger about why they were pushed to file this OPRA request when all they wanted was a simple record, right? You're creating sort of these little pockets of animosity by pushing someone who is using the administrative or informal request process to an OPRA request unnecessarily, and putting yourself in a situation for our agencies who are in attendance today that it could end up in litigation. And here's the other important thing to note about all of these various processes is we have no adjudicatory authority. So if somebody submits a discovery request and certain records aren't disclosed, that person can't turn around and file a complaint with us. Now, they may be able to complain to the court in a discovery request situation. In a common law request situation, their option would be to file in court. In administrative informal requests, as far as I know, there's no real process for anyone to complain. So what you're really looking at here is the GRC is not going to take a denial of access complaint if someone has made a request under any of these processes. So our requesters out there, if you've made a request under these processes, you can't turn around and file a complaint with the GRC. If you filed an OPRA request, you can. Moving along. So as everybody knows, on September 3rd, 2024, at the end of a very short Labor Day weekend for me, the new version of the statute went into effect. We're going to highlight some changes today. We're going to talk about some of the new processes today, a little more in depth than I have been at some of my other seminars based on limited time. And hopeful that those of you take this as a refresher who have been around, and have been here before to see one of our presentations. And those of you who are new, we'll get some good information out of this. All right, so I always begin with what changed for us. What changed for the GRC? So previously, the GRC Council was comprised of 5 members. Now, the GRC Council is comprised of 9 members. The DCA Commissioner and their designee, Mr. John Alexi, is our chair. He's on today. I'm sure he's smiling knowing that I get to talk for several more hours than he normally does in one of our monthly meetings. We have 4 members that were appointed directly by the governor. Robin Berg-Tabakin and Stephen Ritardi, who were held over from the old council, who have been longtime council members. Professor Ronald Chen and Senator Chris Brown round out our current representation of council members. And they're all very good and dedicated to, ensuring a fair adjudicatory process. And we appreciate them very much. We also have 4 members, 2 each appointed by the Senate President and Assembly Speaker. Right now, those spots remain vacant. So we do have, we are experiencing some quorum issues. But that 9-member council, once we get up to full speed, will be able to take us month by month through all of our adjudications. So what's gonna happen with our complaint process? How does that complaint process look now? Well, the statute of limitation that was set by the GRC through its rule promulgation in 2022 has been reduced from 60 days to 45 calendar days. So now we're in line with the court's 45 calendar day statute of limitation from the date of the denial, whether it's a straight denial or a failure to respond. We also wanted to highlight that court actions or GRC complaints can now be dismissed without prejudice if an agency discloses the record sought within 7 business days after receiving the denial of access complaint, but strongly note that attorney's fees may be awarded. We'll talk about that a little bit later. Anonymous requesters are now not permitted to file complaints either with the court or the GRC through 47:5F and 6 of OPRA. However, I will stress that anonymous requests, and again, we will go over this a little bit later, are still permitted and should be treated just like any other OPRA request.
Hey, Frank.
So beginning on February 3rd of 2026, adjudications will have to be done by staff within 90 days after receipt of a complaint. We do have the option of requesting a 45-day extension for good cause, though we don't know to whom we're supposed to request that extension. That's something we'll have to figure out as we get closer to the process. As for additional changes for the GRC, we have our OPRA model request form, which is now the established request form. We had to update it. We updated it back at the end of August of 2024. But we're also going to be required to promulgate regulations to establish a uniform form for use across the state by all public agencies. And we have to make that form available to individuals who are incarcerated within the correction system throughout the state, which of course we did fairly early on after September of 2024. In terms of data compilation, the Superior Court and the Office of Administrative Courts are required to send us a compilation of data for OPRA cases that they're handling. I'm happy to report that we did get that production back in August, and that information is stored on a dashboard system right on our website under About GRC. DCA put together a pretty neat looking dashboard that allows you to look at all of that data in various different graphs, charts, and sort it, so on and so forth. So pretty neat. Thanks to our DCA folks for doing that for us so that the public could see some of this data that's come in. And as we always do, but this has now been codified, we have to periodically review our website for updates as needed. Certainly, we hope to keep the website up to date and as fresh as possible within the scope of the resources that we can use to do it. If you want to peruse the website from time to time, we obviously will periodically update it. All right, public agency. What's a public agency under OPRA? Most of you probably are here from a municipality. Congratulations, you're a public agency. Those of you here from state departments, commissions, school districts, fire districts, congratulations, you're public agencies under OPRA, as well as the Port Authority of New York, New Jersey. I believe the only bi-state agency in the state of New Jersey that is subject to the Open Public Records Act, as well as the League of Municipalities based on a prior court decision, and the legislature, which is also defined as a public agency. Notice the absence of the judiciary. That's because the judiciary is not defined as a public agency under OPRA. They have their own request process that people should follow if you're looking for records from the court. So for our requesters, if you're looking for records from your municipal court, from your county court, from the state superior court, appellate division, Supreme Court, those requests have to be made to the judiciary and not under OPRA, but through the judicial record request process. Information on that can be obtained from the Superior Court Clerk's office. Then we have sort of these weird amorphous quasi-governmental agencies. One particular type of agency that comes to mind is a business improvement district, though potentially not always the case with that particular type of agency, but you have these sort of weird, hey, are they a public agency? Aren't they a public agency? And the typical test, which is a two-part test, it's a creation test. How was this entity created? And a function test. What type of function does this entity carry out to determine whether or not they're a public agency? What's a government record under OPRA? We talked about it. That answer hasn't changed. This portion of the statute did not change. All records made, maintained, received, or kept on file in the course of official business. I will add, regardless of location, meaning it doesn't matter where they're being stored. If they fall within this definition, they are a government record. However, OPRA's exemptions, those in section 1.1, 9A, 5.3, 5.2, I believe, and in other statutes, regulations, executive orders, where they exist, could bring a record out of the definition of a government record. So it would make it effectively exempt under OPRA. That would be in part or whole. In part meaning with redactions, in whole meaning you can deny access in total to the record. Who's the custodian? I would ask for a show of hands if I were in person for who the custodians were for their agencies. Typically for a municipality, it's the municipal clerk, though in more recent years, we have seen agencies sort of bifurcate those functions. Police departments who may designate their own custodian to hold out to the public as the person to submit records to that particular person in the police department for police records. We've seen things like that. The importance of designating custodians in subdepartments, again, like a police department, would be to hold out to the public the idea that, hey, I need to request records from the Burlington City Police Department. Well, if they have their own custodian, that should be held out. If they have their own OPRA request, they're telling the public, this is where you need to send your request for police records. In that way, everybody knows, hey, this shouldn't go to the municipal clerk. This should go to this other custodian. So for non-agencies that designate or for non-municipal agencies that designate custodians, so like the Government Records Council, it's done by formal action. Notice it, by formal action is in quotes. That's because by formal action was not defined. I get a lot of calls about, hey, we're going to designate a custodian for the police department. Do I have to send you a resolution? No, you do not. The statute doesn't require a resolution. By formal action effectively is whatever that agency thinks is formal action. Anecdotally, the way I became the custodian of record for the GRC was I was told, hey, you're going to be the custodian now. Congratulations. That's how it happened. That was the formal action taken now 15 years ago to make me the custodian for the Government Records Council, and I've been the designated custodian here ever since. Now, I will note that best practices dictates that an agency should always designate a substitute custodian. This is very important because you have situations where either seen or unforeseen circumstances show that, custodian may be out. They may be on a long vacation. They may be out sick. They may be dealing with personal family issues. They may have retired, quite honestly. We've seen a couple of situations where a custodian retired and their website was never updated, their email address was left on, and people were still sending OPRA requests. If there was a designated substitute in that situation, those agencies could have avoided a lot of issues. The other thing I'll suggest as part of this substitute custodian situation is you may want to create an OPRA specific email address that both the municipal clerk and the substitute custodian or custodians have access to. OPRA@grc.nj.gov, something, as sort of an example. A lot of agencies are moving toward a singular OPRA email. And it's smart because you have, instead of one person's email, frank.caruso@dca.nj.gov, being the email address that everyone sends their OPRA requests to, there's a shared email address that a couple of people can be assigned to seamlessly transfer the OPRA function from one person to another as may need be based on absences, retirements, so on and so forth. All right, Mia, first big test. We're on to our first poll question, folks. So here's what's going to happen. Mia is going to launch the poll question in the chat. Now, again, remind everyone that we are aware that in some instances, people may not see the poll question. And that's fine. If you don't see the poll question, you can answer in the chat, okay? So Mia, if I'll read the question, and if you want to fire up the poll, anonymous requesters are prohibited from submitting OPRA requests. This is a true/false question. Mia, go ahead and start the chat.
It's up. It should be in the chat.
Okay. All right, so we'll give everybody a little bit of time to answer that. Again, it's true/false. Again, if you do not have the capability or do not see the poll, you can simply answer in the chat. Your answer in the chat will count as your answer for towards your credit. I'll be able to track your participation that way through the chat. This, Mia, what's our percentage look like?
I have 215 responses in the poll and a lot of responses in the chat.
Okay. Again, if you do not see the poll pop up in your screen, just go ahead and answer in the chat. We'll wait a few more seconds. I know there's a bit of a delay for us. So anonymous requesters are prohibited from submitting OPRA requests. Is that true or is that false? All right, we'll wait just a few more seconds and I'll give the answer. Again, anonymous requesters are prohibited from submitting OPRA requests. True or false? If you don't see the poll, go ahead and answer right in the chat box. All right. Any last takers? Going once, going twice. All right. Go ahead and close the poll, Mia. We'll give the answer, which is false. This has been a common misconception with the new version of the statute that anonymous requesters are no longer permitted to submit OPRA requests. That is false. OPRA doesn't permit anonymous requesters. OPRA does not prohibit anonymous requesters from submitting an OPRA request. It does prohibit them from filing a complaint, but they are still allowed to submit an OPRA request to an agency. And again, I will stress to everyone here that OPRA request should be treated the same as any other OPRA request that you would get from a named party. Anonymous requesters still have the same right to file OPRA requests as anybody else, and they should be treated the same as any other OPRA request. All right, that segues us into who can request records. The answer is anyone. That includes anonymous requests, as stated in the last question. That also includes requesters seeking records for a commercial purpose. This is another sort of undercurrent misconception amongst agencies that someone checks, I will use records for a commercial purpose. They can be denied. That is incorrect. Commercial purposes requesters are still allowed. We'll go over what the significance is of that here shortly. Out-of-state requesters, this is pretty much held since the Sheeler decision in 2018. The statute did not change to focus or to otherwise cut out-of-state requesters. So there is no limitation on requesters in-state versus out-of-state, based both on the court's decision in 2018 and the lack of change to the statute in September of 24. Now, as I always note, the identity of the requester may impact their right of access in limited circumstances. So the statute identifies certain limited situations where the identity of the requester may produce a different result than any other requester. So we're talking about situations like someone who's been convicted of an indictable offense, who is looking to access personal records containing personal information of their victims or victims' families. We're talking about employees for government who are seeking their own personnel record under OPRA and are waiving that right. Victims of a crime who have certain rights to access records that maybe some others don't as well. And potentially in situations where you're talking about privacy, we'll talk about that a little later. The identity of the requester and their need for the record may affect the right of access. Jumping right into commercial purpose. So lots of questions about this. The first thing I'll say about the commercial purpose definition is that it can be interpreted in many different ways. Unfortunately, right now, we don't have the benefit of case law that sort of brings into focus really what that definition is going to mean in a lot of situations. So the definition, the direct or indirect use of any part of a government record for sale, resale, solicitation, rent, or lease of a service, or any use by which the user expects a profit, either through commission, salary, or fee. So again, the direct or indirect use of any part of a government record for sale, resale, solicitation, rent, or lease of a service, or any use by which the user expects a profit either through commission, salary, or fee. That is the definition of a commercial purpose. And there are exceptions. We'll note the exceptions here. News media, obviously, uses of the record for news, journalism, education. I don't know why I forgot that S. Education, scientific, scholarly, or governmental organizations, use by an election candidate, labor unions, especially as it relates to contract, signatory, and collective bargaining material, and nonprofits who don't intend to sell that information to an unaffiliated third party. So these would be the exceptions. People falling within this would not have to identify themselves as commercial purposes requesters. We've gotten a lot of questions. What if an attorney is requesting records on behalf of their client? What if a real estate agent is requesting information on a particular property that they're representing someone who is either buying or selling? I had an interesting one the other day. What happens if a company is using OPRA to try and obtain access to bid submissions for an RFP? These are the kinds of things that right now we're just kind of looking at the plain wording of the statute and saying, this is what the definition is. If you think you're a commercial purposes requester, then you should check yes. The importance of not checking yes when you know you're going to use records for a commercial purpose for our requesters out there is that there's now civil penalties if a person is found to have falsely certified that they're not going to use the records for a commercial purpose. So, it may be better than not if you're not entirely sure whether or not you intend to use the records for that commercial purpose, but you think it might be on the borderline to say yes. Again, false certification is a high standard, but at the end of the day, because of the amorphous nature of this definition, I think you're kind of going to be stuck in a weird place. So for our attorneys out there, for our real estate agents out there, it's sort of an odd situation because we don't really have good case law at this point that will say, hey, that's a use that the court has found or the GRC has found as commercial purpose use. So you should be checking, based on those decisions, you should be checking, I am going to use the records for a commercial purpose. All right, OPRA forms. So we talked about it briefly. We'll talk about it a lot more here. Effectively, now OPRA requires, hard underline requires, every public agency who is subject to the Open Public Records Act in the state of New Jersey to adopt our form. We used to have the model request form, which we offer to agencies to make it easier on them to not have to create an OPRA request form. That form has now been converted into the established OPRA request form. And that established OPRA request form is required to be adopted by every agency subject to OPRA. School districts, municipalities, county agencies, state agencies, the legislature, everyone who is subject to OPRA is required to adopt that form. We're also required to promulgate regulations to establish the form. We're in the process of doing that. We have heard some feedback from folks about our form. So we're certainly taking looks at that as we consider promulgating regulations as required by the statute. But the major changes from the old form to the new form, first and foremost, the commercial purposes question and the question about whether or not records sought are being sought in connection with any litigation. Those two questions have been added to the top of the form. We've expanded and changed the exemptions checklist, which was on page 2 into 3. To ensure that it reflects the new state of the exemptions within the statute. And we made extensive changes to the information page. Many of you probably remember when I would talk about the number of forms I see out there that had name of agency on the last page because people didn't take the placeholder stuff out. Well, all of that stuff, that placeholder stuff is gone now, and there's a lot more information that is directly related to how the statutory process works now, as opposed to before September of 2024. If an agency is maintaining their form electronically, it is required to provide directions on how to submit that electronic request to the agency. That's an interesting note, but an important one. You want to make sure that requesters are clear on how they have to submit an OPRA request to you electronically. As for our form, we placed it in a portal system that would allow someone to put their information in. They would then turn around and that portal system would then spit back the established OPRA request form for them with their information on it. What we didn't realize back in August of 2024 was that when our portal system went live, Adobe was going to be nice enough to password protect every form it sent out to all of you in the custodial world and in the agency world. What we found out shortly after getting emails on that issue was that Adobe creates a password that doesn't go to anyone or go anywhere. So we had no password because apparently one didn't really actually exist, or it did, just no one knew what it was. So we did come up with some troubleshooting so that people could add logos to the top of their established OPRA request forms. We've also been suggesting that if you had an old model request version of your OPRA request form, that you should still go onto the portal and obtain the new form. And any agencies operating with online platforms at this point should have updated their platform forms to comply with the new elements, including the two new questions. So we're now more than a year into this. Hopefully everyone has done this at this point. Everyone of our agencies who are in attendance today have all gone onto the portal, have all gotten a copy of the established request form sent back to them, and are now utilizing that form as their official OPRA request form. All right, so how does a requester submit an OPRA request? Still the same: hand delivery, mail, electronic transmission, or otherwise conveyed. These submissions could include portals and online forms and software utilized to submit OPRA requests. Agencies, we believe, may still be able to limit submissions options based on technological capabilities. For instance, the GRC doesn't have a portal, so obviously we wouldn't be able to offer a portal submission if somebody wanted to submit an OPRA request to us. Of course, with the I guess potential death of fax machines, you know, what came out of past the city of East Orange was a fax machine issue. Who knows if fax is still part of the equation, but it could end up being, still part of the equation. So the question of limited submissions to the extent that they will not present an unreasonable obstacle to submitting an OPRA request still is something that I think we would have to contemplate. So written equivalents, to get to that point, are still allowed. That means still that statute supports that an individual is not required to use the agency's official OPRA request form. But unlike before September of 2024, they now must include all components required by 5F and 5G, meaning that that written equivalent should basically look like the form in some way, shape, or form. It should have the answers to the 3 questions that are on the form. It should include all of the contact information. It should include what the actual OPRA request is. Again, I will note that written equivalent also can't include substantially more info than required by the form. So I believe that this particular portion of the provision really speaks to the idea of you can't send, requesters, you can't send someone a 5-page letter, an agency a 5-page letter, and right in the middle of that 5-page letter, there's an OPRA request. This is really about ensuring that the written equivalents are now not buried in some longer submission, that they're not, that they're not difficult to discern that it's an OPRA request, whatever the case is, that basically any written equivalent is more of a short and succinct type of request. Are there limitations? There are limitations. To the question about whether or not records are connected to litigation, that question. It's no longer possible for requesters to utilize OPRA to seek records that are already the subject of a court order or pending discovery request. And they have to certify as to whether or not they're requesting records that are connected to that litigation. This is not going to apply to labor unions to the extent that they're seeking information that is dedicated to finding out whether or not agencies are complying with certain labor laws. However, generally a requester now is pretty much stuck in a court order or discovery process and can't simultaneously seek the same records under OPRA and through those other court processes. Important thing to note early on, a lot of custodians said, well, if they check yes to the litigation question on the form, we can deny access, we can deny that request. That is incorrect. As currently worded, that question would require the agency to then go and see whether or not there's a pending court order or a discovery request that seeks the exact record being sought. So Frank Caruso is seeking body-worn camera footage as part of a discovery request in a municipal court action. Then Frank Caruso submits an OPRA request for the same exact body-worn camera footage while he's still waiting to hear back on the discovery request. In that situation, that would be a place where a custodian could deny access to the OPRA request. But if Frank Caruso is simply seeking body-worn camera footage and is in the middle of defending himself in court but has not sought it through a court order or discovery, then by the wording of the statute, the OPRA request should be honored there, at least to the extent that the record is disclosable, and not denied on the basis that Frank Caruso is simply involved in litigation. So that's an important distinction. The record being sought under OPRA also has to be part of a pending court order, including an open discovery request. Requesters can only submit a request to a single custodian within one public agency. So there's been a little bit of conjecture about whether or not this means that Frank Caruso has to submit an OPRA request to the Government Records Council and then wait for an answer, and then submit the same OPRA request once they get the answer to Codes and Standards and wait for a response, and so on and so forth, as a way to stop, say, and Asbury Park Press for many years would send requests out statewide for personnel information that they would then post to a website for the general citizenry to look at. There was some talk that this language would stop that from happening. The GRC sort of sees this as something different. This would be a situation where an individual wouldn't be able to submit multiple OPRA requests to multiple individuals or custodians within one individual agency. So, or send one OPRA request to multiple agencies as one recipient. By way of an example, we had an individual who filed a complaint here. He had sent an email to 44 separate entities. And then right in the middle of that email was an OPRA request. And when no one responded to it, he singled out one of those entities and filed a complaint against them. Obviously, the council found that there was no reasonable way that that entity could have known that the OPRA request was for it, let alone only for it, and determined that the request was invalid. The GRC suspects that that may be what is at issue here with this particular provision. And finally, with identical requests. So this speaks to the idea that Frank Caruso requests the January reorganization meeting minutes. Frank gets them. 6 months later, Frank requests the January reorganization meeting minutes again. Frank gets them. 6 months later, we start again. 6 months after that, we start again. So here's the deal with now identical requests. To the extent that a requester submits a request for the same exact record after it's been disclosed to them, and nothing in that record has changed, a custodian may now deny access to that record. So I'll say that again, it's important. If a requester submits an OPRA request and obtains a record, and then subsequently submits an identical OPRA request for that same record, and nothing in the record that was disclosed has changed, then the agency can deny access to the request as an identical request. What happens if you're not the custodian? Many of you on here today may not be the custodian for your agency. In fact, every employee, official, officer, appointee in the state of New Jersey, elected official in the state of New Jersey, that isn't a custodian, still has an obligation to know what to do if they receive an official OPRA request. And that is still under 5H. That hasn't, the only change that was really made to 5H is that this last bullet here, the request will not be considered received until the custodian receives it. So we'll back up. So what is that obligation? The obligation is the same as it's always been. If you are not the custodian for your agency and you receive an OPRA request, you have one of two options. The first option is you return the request to the requester and direct them to the appropriate person or place to file an OPRA request with their agency. So, hey, I've received your OPRA request. This is not the correct place to submit it. Submit it to OPRA at grc.nj.gov. That's not a real email address, by the way, so don't try to use it. That's just an example email address. Or Frank Caruso is our custodian of record. Please send the record directly to Frank Caruso at, email address, mailing address, so on and so forth. That's the first way a person is supposed to handle the request. The other way is that the person directs the OPRA request to the custodian of record. So Frank Caruso gets the OPRA request and sends it to the proper custodian internally for handling. So you have those one of two options. Return the request to the requester, direct them to the custodian, or forward the OPRA request directly to the custodian. It puts a lot of onus on the agencies to ensure that their employees understand and know what an OPRA request looks like, so that if they get one, they can fulfill their 5H obligation. So, make sure that all of your colleagues, those of you in the agencies, make sure that all of your colleagues or your clients know, hey, this is what an OPRA request looks like. If you get one, this is what your obligation is under the statute to either send it back or to send it to me. And again, the request will not be considered received until the custodian receives it. All right, so let's talk about the art of the OPRA response. Let's start in the most obvious place. A response always is required to be in writing. No oral responses, no telephonic responses. If you're gonna call somebody on the phone or you're just gonna talk to somebody at your desk or your window, you should immediately, my custodians out here, follow that up with a written response. This is also the case in situations where you may be offering inspection. You know, requesters may want to inspect your record. Not as much anymore, obviously. We don't see that very often. But when I first started here, we saw that quite a bit. And one of the biggest things that would happen would be somebody would come in, a requester would come in and inspect a record. Custodian would say, hey, here they are, come and see them. Requester would come in, requester would leave. 6 weeks later, requester would forget that they came in and inspected the records. They would file a complaint, and the custodian would say, but they came in and looked at them. They never responded in writing. They never had a cover letter or an email that said that confirmed that the records were inspected on this date. They never had any of that. So ultimately, it would end up looking like a deemed denial. So everything that is a face-to-face or an oral response or a telephonic response should be placed in writing in order to ensure that everybody knows, both requesters and custodians know, hey, I responded, because this is what the statute requires. So we have within the required response time, there are some changes to the response time that we'll go over. And you have to do one of these 4 things: grant access, pretty self-explanatory, deny access, seek clarification, or request an extension of time to a date certain. There are some changes to a few of these, items. We'll talk about that, but this is still the 4 ways to respond. Now, we'll get into the timeframes, and we start right at as soon as possible. Yes, it's underlined because this is a bold type, and bolding didn't do anything to make it stand out. But no later than 7 business days after receiving the request. I've been giving OPRA outreaches now for many years. I'm pretty sure that some of you have seen me a lot, are tired of hearing a lot of the things I have to say, but they are nonetheless very pertinent, and none probably more than the as soon as possible threshold. Now, obviously, all custodians have up to 7 business days to respond to an OPRA request in most instances, the exceptions of which we'll talk about. However, agencies should not be in the practice of routinely waiting until the 7th business day to respond to an OPRA request. Because here's the reality: life happens. Sometimes it happens very, very quickly. And you could be saying, hey, we're just going to respond on the 7th business day. And then you're out sick, or you're indisposed for some reason. And now all of a sudden, the 7th business day has come and gone, and there's a deemed denial. And the deemed denial, I will note, I have taken it out of the presentation, but I'll still continue to remind everyone, deemed denials are still, all these years in, 23 and a half years later, our top finding with the Government Records Council. So as soon as possible is important, because if an agency has an OPRA request, it's fairly easy to respond to. Why not respond to it and get it off your plate instead of waiting the 7 business days? Again, 7 business days is the general threshold, but as soon as possible gives you the impetus to just respond to the OPRA request as soon as you get it. I think the average response time frame here at the GRC is 3 to 4 business days, if that. So, and understanding that custodians, especially municipal clerks, have a ton of different things to do, and they may be relying on other people to search for records, so on and so forth. But it's important to just stress the idea that the quicker an agency can respond to an OPRA request, the better it is for everyone. Requesters happy because they got the records they were looking for quickly, or at least they got a response quickly and they can figure out what to do next faster. The agency's happy because they've now got one less OPRA request to respond to because they've responded quickly. There isn't that same amount of pressure to try and hurry up on the last business day and shoot out a response before you leave for the day. It probably causes less confusion in trying to keep together what stuff is at its 7th business day. So just best to really look toward that as soon as possible standard. Exceptions, again, immediate access records, information contained in 3B, we call it the 3B information. I'll go over them sort of individually and quickly. Then you have your commercial and Daniels law requests, election records, and what happens during a state of emergency, which effectively means that during those very specific types of a state of emergency, there is no response time frame. Fire districts, congratulations. If you have one or fewer full-time employees, you get to add 7 additional business days to any one of these various time frames. So this 5A, we're going to talk about OPRA hours. And interestingly enough, this was not changed in the statute, in the statutory changes in September of 24. This was not added. This has been here since July of 2002. And it speaks to the idea that agencies of a certain size can limit their OPRA hours down to essentially 2 hours a day for 3 days a week, or the agency's regularly scheduled business hours, whichever is less. So up to 6 hours a week, or if the agency's business hours are less than 6 hours a week, they can limit those OPRA hours to that time. And municipalities with 5,000 or less, if any of you are on today, limited OPRA hours would apply to you. Hey, boards of education with 500 or fewer in total enrollment, if you're on today, technically you could limit your OPRA hours to this standard under 5A. Any public authorities that are here today with less than 10 million in assets, not really entirely sure whether or not one of those exists anymore. But if you do, hey, you have the ability to limit your OPRA hours. The important thing about this is that if you do fit within one of these three types of agencies that has the ability to limit OPRA hours, you have to hold out to the public that your OPRA hours are limited. You can't just kind of goof around and say, oh, whatever, we'll deal with it. And then when someone files a complaint, try and make the argument that, well, we had limited OPRA hours, so our response was timely. The GRC is going to want to know, well, who knew? Who knew that you had limited OPRA hours? Because if nobody knew, you didn't hold it out to the public, then we're not buying it now that you actually limited your OPRA hours. So if you are within one of these three categories and you want to limit your OPRA hours, that has to be held out to the public, has to be made publicly notified that you're doing that. All right, immediate access. The big change with immediate access, again, budgets, bills, vouchers, contracts, including collective negotiation agreements and individual employment contracts, as well as public salary and overtime information. That has always been the immediate access provision. The new change here is that it now only applies to records 24 months prior to the date of the OPRA request. So if, requesters, if you're looking for 10 years worth of bills under the old statute, they would technically all have been considered immediate access. Now, if the requester is looking for 10 years worth of bills, only the preceding 2 years worth of bills are subject to the immediate access. The remaining 8 years worth of bills are subject to the regular timeframes. So that is a change under 5E that is new and important under the new statute. I will note that longstanding case law that the response itself has to be immediate. Back to the 10 years worth of bills example, it's probably going to be unlikely that any agency is going to be able to produce 10 years worth of bills immediately. So the response at least should be immediate. Also, what happens if that 10 years worth of bills is part of a larger OPRA request that contains a lot of other request items that aren't immediate access items? The OPRA in our case law requires that response to the immediate access item has to occur immediately, but then you handle the rest of the request in the normal course of business. So you want to make sure that if somebody requests 5 records and 2 of them are bills and salary information, that those 2 request items are being addressed immediately and the other 3 are being handled within the regular time frame. All right, 3B information for our police departments. There's 2 categories of types of information on criminal investigations that are required to be disclosed within 24 hours or as soon as practical. They are very clearly outlined in 47:1A-3B, and they're in 2 categories: when crime is reported but no arrest has been made, and if an arrest is made. The North Jersey Media Group v. Lyndhurst Court actually suggested that it might make sense to create for agencies to have on hand sort of a brief document that for all of their criminal investigations, they could include this information on there for when a request for the information has been made. I haven't really seen anyone do that since the North Jersey Media Group case came out, but certainly may not hurt. There is a caveat in a situation where this information could be withheld, and that's if it's determined to jeopardize the safety of any person or the investigation in progress. All right, so now on to commercial purpose and Daniel's Law. So we'll talk about the Office of Information Privacy will give you some information on at least the inner workings of its operation in terms of handling covered persons and redactors, covered persons applications and redactors. But what happens if you receive an OPRA request and you believe there may be Daniel's Law, exempt Daniel's Law information on there? And what happens if somebody checks, I will use the records for a commercial purpose? Well, in the commercial purpose instance, they check, I will. The deadline to respond now is 14 business days, but custodians have to notify that requester within the first 7 business days that the response time frame is 14 business days. There's also an option for the commercial purposes requester to reduce the time frame to 7 days by paying no more than 2 times the cost to produce the responsive records. The big question that everyone's probably asking themselves right now and has been asking themselves for some time is, what happens if the cost for the OPRA request for a commercial purposes request is 0? My staff knows, because we've talked about it at length even in the last week alone. Many of you probably know, because you've heard me say it before, that I legitimately changed my major in college because I didn't want to take another math class, but I'm still pretty sure that I can determine that 0 times anything is 0. So the question remains, what happens if the cost is 0? Can a commercial purposes requester actually pay down that cost of 0 to get to 7 business days? And we're not really sure right now. So stay tuned. I'm sure it'll come up eventually, and we'll have a better answer before most of us retire. That would be good. But that's generally the gist. The important thing is, yes, the response time frame goes to 14 business days, but custodian has to notify the requester of that extended response time frame within the first 7 business days. Similarly, if a request comes in and the custodian believes that there is Daniel's Law information that needs to be reviewed and potentially redacted on the records requested, the 14 business days with notification and 7 business days does apply as well. So for your commercial purpose, that's the significance of someone checking yes. That means that their response time frame goes to 14 business days. If you think, custodians, if you think that there is Daniel's Law address information in a record that's been requested that needs to be reviewed and redacted, then the assertion, the response is within 7 business days, hey, we have to review for Daniel's Law information, and the response time frame is 14 business days now. Election records. So the election has just passed, but there's always another election, I'm sure. And it's very important that municipal, county, and state custodians who are dealing with elections, who are elections officials, or who are holding their own elections, get very familiar with 47:1A-5.3. This speaks to not only what should and shouldn't be disclosed with or without redactions, but in the case of C, D, and or in the case of C and D, what is the time frame to disclose this information? And unfortunately, C and D are connected to, or at least D is connected to so many days before an election, and what those timeframes are. But it basically creates an immediate access. It creates an immediate access standard for certain election records, but is capped at 2 business days in most instances. And with D, you're looking at a situation where that immediate access is really connected to how many days out from the election are you. So get very familiar with 5.3. in terms of elections records, it's important to know exactly what's going on there so that you can deal with any requests that are coming down the pike, especially on the in advance of any upcoming elections. All right, I'll leave this here. Tips momentarily. Tips for responding. These are the things you want to ask yourself. This slide has been in most of our presentations. It's just a tips and tricks slide. It'll be on the presentation, which will, again, just to mention, posted to our website after today's presentation. Just some food for thought as you go through. So we talked about our response types. Here they are. So here they are in a little bit more of a breakdown. Granting access, obviously, very, very clear. Note the medium and method requested. So I would like these records electronically via email. That's how you would grant access. Don't forget about the new timeframes for certain types of requests. Amended provisions that may, we'll talk about the amended provisions that may affect the medium discussion. On to lawful basis for denial. Have to provide a specific lawful basis for denial at the time of your denial. So you respond in writing, custodians, I'm denying access to this request for X reason, right? We'll go in a little bit more in depth of that. Extensions of time. Traditionally, to a date certain, we still think so. There's new extension provisions. We'll talk about those. And then clarification is an option, but not a requirement in a situation where you believe a request may be invalid or unclear. Again, we'll talk about them individually, starting with granting access. Again, fairly self-explanatory. The one thing we want to talk about here is the addition in 5E of a custodian's ability to direct a requester to a website for the record if it is complete and unabridged, meaning that the record that's posted to the internet has not been changed, altered, redacted, excised, cut, edited, or abridged in any way. So if you have your meeting minutes up there, and it's a complete and full copy of the meeting minutes, and I request meeting minutes, custodians, you can direct me to the exact location on the internet where those responsive minutes are at, and the request would be considered fulfilled if I didn't come back to you within 7 business days. But then we get into what I've dubbed to calling the 777 rule. This is what happens once that response has been sent, right? So custodian, hey, this is where the record is. If I don't respond, me as the requester, don't respond back within 7 business days, the request is obviously considered deemed fulfilled. But that's the first 7. But if I do respond back to you within the 7 business days and say, hey, I can't for the life of me access this record. Now the custodian has 7 business days to attempt to reasonably assist the requester, my favorite word, reasonable, to assist the requester in order to try and get them to locate the record and access the record, right? So that's the first 7, or that's the second 7. So you have the first 7 for notification that I can't locate the record. The second 7 for the custodian to assist me in trying to obtain access to the record. If that's not working, and basically I go back to the custodian and say, hey, send me a physical copy, please. The custodian would have 7 business days to send a physical copy to me and can charge me up to 2 times the cost for duplication. That's the third 7. So the 777. 7 days to notify if there's an issue obtaining the record, 7 days to assist the requester or business days, sorry, make sure you're adding business in that. 7 business days to notify the custodian that there's an issue obtaining the record, 7 business days to assist the requester to obtain the record, 7 business days to disclose the record in a physical copy at no more than 2 times the duplication cost, 777. Lawful denial. This is still something that custodians don't always get right, usually maybe for some of the newer ones. But unfortunately, it's something that really we need to focus on a little bit more, I think, across the board, because we still get complaints here where a custodian's response was, yeah, we're we're not going to give that to you, or access denied, request closed, or no, these records are exempt. There has to be more than that. Specific lawful basis. These records, this social security number has been redacted under section 47:1A-1.1. These draft meeting minutes are exempt from disclosure as ACD, or advisory consultative and deliberative material, under section 1.1. This record is, this incident report is exempt under the criminal investigatory exemption, right, under 1.1, whatever the case is. There has to be more than just, you can't have it, we're closing your request. And that stands, again, for situations where something's been redacted, or in situations where the entirety of the record is being denied. I'll also caution agencies on the idea that some of these exemptions they have qualifiers. They say the record is exempt under this exemption if, right? We'll go back to the 3B information. 3B information can be withheld if disclosure would jeopardize the safety of the individuals or the investigation, right? Ongoing investigation records can be exempt if disclosure is ultimately inimical or harmful to the public interest, right? So the agency has to be prepared in those situations with these sort of the record is exempt if exemptions to be able to argue these are the reasons why we fit the if, right? That's important because, just saying, well, this exemption applies isn't going to be enough for agencies. And I know there's some requesters or attorneys who've represented requesters who are on with us today who have looked at those types of denials and are wondering, well, what about the if? What about, how can you tell me that what can you tell me about this is an investigation in progress, but disclosure of the records in question would be inimical to the public interest, right? I don't see how that's the case. That's the important part of ensuring that there's qualified kind of exemptions that agencies are prepared to say, well, this is why, if occurs. All right, Mia, time for poll question number 2. We're going to go through poll question number 2, and I think we're going to take a break. I'm sure everybody wants to stretch. We'll get through the rest of the, and we'll go through the rest of the slide presentation. Without further ado, PL 2024 Chapter 16. That's the bill that or the law that ultimately became the new version of statute, the new version of OPRA. Did not contain any additional exemptions or changes to the existing exemptions. True or false? 2024 Chapter 16 did not contain any additional exemptions or changes to existing exemptions. Is that true or is that false? Mia, go ahead and launch the poll. I said it with the last poll, but I will continue to remind folks throughout the day. If you do not see the poll question come up, you can respond in the chat. The GRC will accept your chat-based response as proof that you are still awake and that you have not abandoned all hope the second we lost feed with our slide presentation. Again, PL 2024 Chapter 16 did not contain any additional exemptions or changes to existing exemptions. Is that true or is that false? A little bit more, Mia. Oh, I can actually see it now. We have about 218 responses in the poll.
Yeah, 220 and a bunch in the chat. It seems like most people are doing it in the chat.
Yeah, I'm seeing this chat window is going wild right now, so that's a good thing. It means everybody's getting their responses in. All right, Mia, we got about 230 responses. We have a bunch more in in the chat, so that's a good thing. So if you want to go ahead, Mia, and close the poll, I'll give the answer. Okay, let's go. The answer is false. In fact, PL 2024 Chapter 16 included a few new exemptions and changes to multiple existing exemptions. And we'll go over some of those a little bit later. So the answer is false. I do see that we do have some questions in the Q&A side that hopefully when we come back from break here, we'll be able to maybe get to a few of them. We're about halfway through the slide presentation. I do want to take a break, about 10 minutes, starting right now at 10:45. We'll resume at 10:55. So if you don't hear anything for the next 10 minutes, that's because we're on a break. I'll leave the poll question, or I'll leave the next slide up. And again, this is where we're going to go, right to highlighted exemption changes. We'll be back in a few minutes. We'll just take this quick 10-minute break till 10:55, and we'll resume promptly at 10:55. All right, thank you. We'll be back shortly. There were a few questions in the Q&A. We're going to have a little bit of a rushed run to the end of this to get everybody out for lunch on time. Mia, did you have a question or two? I know there were some coming up in the Q&A.
Yes, they were mostly about the requester.
Okay.
The first one is if anonymous requesters are allowed, then how would the custodian know questions like if they were convicted of a felony, if that was correct, or request for a personnel file or student records? How would the custodian verify if the requester is the person submitting the request?
So if the request is anonymous, you would look to basically Section 2.2 would speak to the idea of what happens when there's an anonymous request that may be seeking access to information related to a victim or a victim's family. And they should be treated the same as if somebody checked yes to the indictable offense question. But really, when you get into some of the other stuff, in terms of like student records or so on and so forth, there is a chance that some of that stuff is already exempt anyway. And that there may be certain situations where the identity of the individual could impact access. However, if you don't have the identity of that individual, obviously it would, that particular thing, let's say in a student record situation, right? Certain individuals can obtain access to a student record. But if they're not identified, obviously, then they wouldn't meet that threshold.
Okay, and
Anything else?
similarly, a couple questions about attorneys and law offices. One custodian said that, let's see, law offices send OPRA requests all the time, and they say it's for their client, but they check the box no for litigation. Is there a penalty, or what should a custodian do if the OPRA request is basically cut and paste discovery demands?
Well, I mean, so the connotation of a cut and paste discovery demand. I mean, most often, if any of our folks on here have been familiar with seeing the difference between an OPRA request and a discovery request, is that discovery requests are most often fairly broad. And at least in my experience, from what I've seen, is that a lot of the discovery requests would likely be considered invalid under OPRA because because they're really more or less like that any and all documents related to a particular situation type of request. Again, in a situation where an agency is receiving an OPRA request that looks like a discovery request, but then they also know that there is a simultaneous discovery request from that individual or from that individual's attorney, looking for the same documents. And part of the litigation question requires the individual to identify what the matter is, which should make it easy for a municipal clerk or a custodian or whoever to go to whoever's handling their discovery and court orders and say, hey, do you have a discovery or court order for this particular case? And if so, are they requesting these records? And then that'll give you an idea. Of whether or not you can deny that request on the basis that they're seeking the same records under the court order or discovery request. But then from there, in handling those requests differently, it does really come down to, okay, Disclosing the records under OPRA comes with its process. Review, are they government records? What are the exemptions that apply? Should they be redacted? Discovery is going to be a completely different issue. Not really one I can give guidance on, but one that, would be good to talk with your attorney about, and what the different thresholds for disclosure would be with discovery. So.
You have
All
time
right.
for one more? Or
One more. Yep. Yeah, let's go one more.
so a couple people asked if there's any recourse or anything custodians can do if there's an OPRA request that gets lost through no fault of the custodian, like lost in spam, or if the request is buried in a letter, like a long rambling letter. Is there anything that they can do? Seems like if they missed the deadline or something like that.
Well, I would say that agencies should make a habit of checking their spam files first and foremost. You should always check your spam file, a couple of times a week, 3-4 times a week. I check our spam folder every day, sometimes twice a day, just about. So you should always be checking, because in the world we live in now, and the way our email and internet tends to work, that occasionally you'll get stuff that you'll be surprised is in spam. But then like I've actually had email chains where half the emails came to me, half the emails ended up in spam. Makes no sense. So you should always be checking your spam. I mean, in a situation where effectively a request might have been missed for any reason, I mean, whether or not the requester is going to be okay with an explanation that the request was missed, I'm not really sure. But penultimately, if a complaint gets filed, we'll just have to look at what the circumstances of each of those requests are, and make a determination as to whether or not there ultimately was some type of a deemed denial issue. So we left off with exemptions. Here are some of the highlighted changes. Again, when we talk about this, and one that I wanted to point to directly was the security alarm activity, access reports, and security footage. This does represent a change from the way that this was handled in the past. Most specifically before, especially with security camera footage, the GRC has found repeatedly since Gillern v. Bloomfield that those records are exempt from disclosure. But now there's an avenue by which people may be able to obtain certain limited sets of footage where they can identify a limited incident within a reasonable time frame. And again, to my point before we went to break, disclosure would not jeopardize the overall system. So this is one of those qualifiers. Does access jeopardize the overall security system? An agency should be prepared to, if they're saying we're not going to give this security footage to you, the agency has to be prepared to argue that disclosure would jeopardize their system. We have some expansion of personal information exemptions, including juvenile information, owner manuals, HIPAA data, metadata, except for very limited types of metadata, indecent graphic images and photographs or video. So this is sort of in response to about 1.5 years ago, 2 years ago, there was a lot of talk about YouTube channels posting DUI, body-worn camera, and mobile video recording footage of young adult females. Obviously, they want to make sure, OPRA and the legislature wanted to make sure that these images were above board and that there weren't any salacious images that are going out. So 5.2 addresses that. And then we have our exemptions, our exceptions and exemptions. Exceptions and exemptions for election records. All right, extensions of time. So previously, the extensions of time to a date certain were basically, hey, I need an extension of time. Here's the date certain. Now they come in 2 types. If you have records in storage, you're capped at a 21 business day extension of time, up to 21 business days from the date the custodian says, hey, these records are in storage. We need an extension to retrieve them from storage. You have to inform, if your custodians out there, if you have this records in storage issue, you have to inform the requester. You have to inform the requester of the extension up to a date certain, and you only get up to 21 days. Then there's a second one. This is the most normal reason, the normal one, which is basically unforeseen circumstances. There's some reason why you can't respond to the request within 7 business days, and you would provide a date certain. The extension notification has to be within that statutory time frame, and the extension has to be reasonable. Now, here's a common misconception amongst requesters out there in the world right now, that when a custodian obtains an extension based on unforeseen or reasonable circumstances, that they have to provide at that time the reason why they need the extension, and that if they don't, it's a violation of the statute. In fact, 5I1 does not require the custodian to say, this is why I need to obtain the extension. However, I would argue that best practices dictates that there is some explanation as to why there needs to be an extension, whether it's, we're having trouble locating the records, we're waiting for another department to get back to us, and they need additional time to conduct a search. We have 500 OPRA requests and a broken seminar that we're trying to run, so we're going to need additional time for that. Whatever the case may be, right? I would argue that it's always best to describe the reason why you're taking the extension, why you need the extension. The extension has to be a reasonable one. So you can't just decide you don't feel like dealing with someone, custodians, and they filed 10 OPRA requests in the last year and they're not particularly nice, whatever the case is. So we're just going to start hitting them with 30-day extensions so we don't have to deal with them. That is not a reasonable circumstance. A reasonable circumstance is there is a reason you cannot get to the OPRA request, and it has basis in what your current workload is, what's actually happening with the request, not simply you just feel like you need to take an extension because that's just what you do. That's not going to be reasonable. So make sure that if you are taking extensions, those extensions are rooted in a reasonable base, because that's what the statute now requires. And we'll look at them just like we have all these years since the Cicerone case, which is, hey, what are the circumstances under which the extensions were taken? And are they reasonable within the confines of what we're being told? So unforeseen reasonable circumstance, it has to be reasonable. We'll address this situation just like we have in the past with Cicerone v. Department of Treasury and going forward. And the failure to grant or deny access, again, by that extended time frame or any statutory time frames, is a deemed denial. All right, seeking clarification, pretty straightforward. Make sure that as custodians, make sure you need clarification. If someone's asking for the January reorganization meeting minutes, that's probably not going to require clarification. But if you're asking yourself, I'm not really sure what this requester is requesting, that may be ripe for clarification. As with the past version of the statute, we've not seen anything to indicate differently, that once you receive that clarification, the response time frame begins anew. Here are some things to think about when you're responding to an OPRA request: how it's going to be proper, whether it's going to be proper. Again, this is a list that we keep in most of our presentations, so I'll move past that and we'll move on to overly broad and invalid requests. To the question about discovery style requests, again, we're not in the discovery world here, so this is going to really fall on whether or not the request is valid under OPRA. And that validity typically falls into 3 types of categories. Requests seeking any and all records, very generic, any and all records, right? Now, I would be careful not to see any and all and just stop reading, because there's potential that any and all comes before a series of actual requests that are valid. So don't discount any and all as an invalid request without actually reviewing the whole request. If it's looking for any and all records or documents related to the 17th annual seminar, that likely would be something that's invalid under this first version. We've got requests seeking information or asking questions. How many people attended the 17th annual OPRA seminar? Or what is the number of people that attended the 19th annual or the 17th annual OPRA seminar, right? Those are the types of requests that would be invalid when they're seeking information or asking questions. Though on the information front, I would caution you all because if they're seeking electronic information, so like spreadsheets, database information, that's going to be looked at much differently based on Pat v. Galloway than what's the number of teachers that work in your school district, or how many teachers work in your school district. All right, so you want to be careful there. And then you have basically the third type of invalid request. It's either not on the official OPRA request form or in that equivalent. It doesn't invoke OPRA in any way. It may be on some other type of request form, like a judicial records request form. It may be for our corrections folks, an inmate record request form. It may be a driver privacy protection application, right? Which I think was the issue with Naples 2008-97. Those are not OPRA requests. Those are just requests that follow a different path, a different request type. And in a situation where an individual submits a request like that and then turns around and files a complaint, it's an invalid request for our purposes because it's not an OPRA request. All right, so correspondence. We're talking about a slightly new standard than the one we used to deal with under ELCOVAGE. ELCOVAGE had a broader application of senders and recipients that would allow individuals based on Burke v. Brandis to submit OPRA requests that really sought all emails between the GRC and local government services related to accreditation for the 17th annual seminar between January 1st and December 15th of 2025, right? Now, this recipient or the senders and recipients really are down to specific job titles or accounts. So the executive director, the mayor, Frank Caruso's email account, the specific subject matter, which really hasn't changed from the subject or content, and the reasonable underlying time period. Reasonable to who? We're not sure. Ultimately, what's going to be a reasonable time period for 500 of you in this chain may not be a reasonable time period for the other 500 of you in this chain. So that reasonable threshold is going to be difficult to really kind of determine, but it's probably going to be more limited in scope as we deal with more complaints on the issue of requests for email and correspondence. Note this standard also applies to text message, social media posts, and other types of messaging platforms. So this is emails and correspondence generally, not just emails, not just letters, not just text messages. This is all types of correspondence. This is going to be the valid way to request those types of records. Possession. So this is a two-part thing. One that's very clear. It's in that it's reasonable that custodians of a particular agency are not going to have physical access to every single record being maintained in their agency. So in those instances, it's going to be required for the custodian to contact the appropriate employees or other officials to obtain potentially responsive records, up to and including third parties, right? The best guidance I can give the custodians in those situations is make sure those transactions are in writing so that you have a paper trail as you try to contact the other individuals and obtain records from them for if a complaint gets filed. If you're getting a lack of response from those other individuals, you can show that those individuals have not been responsive to you. Then there's a second type of possession, and this is new in the current version of the statute. It basically states that a public agency shouldn't be considered in the possession of a record when it was given to them from another agency by either remote access, or they could access it through remote access, or it was given to them as a courtesy copy. Now, this is not going to apply in a situation where the record is residing with the judiciary. So we're talking about ECDR forms, which are the summonses, ticket summonses that get produced on the judiciary side. This is a situation where either you have remote access to a record that's being maintained by another agency, or they've given it to you as a courtesy copy. The issue I see with this particular piece is we're not really sure what courtesy copy means. What's the extent of courtesy copy? But notwithstanding, if the agency gets a request for a record that falls into one of these two categories, then effectively the custodian is not required to disclose it, but instead has to direct the requester within 7 business days to the agency that's creating, maintaining, or received the record. So that's the obligation on the agency. You know, if you have access to the record, but it's not your record, you got it as a courtesy copy, you know, from the prosecutor's office, right? Then the correct response would be, in that situation, we're not said to be in possession of this record under 5I1. You need to contact the county prosecutor's office directly, and that response would have to be proffered within 7 business days. OPRA copying costs. Nothing here has changed. This is all pretty much straightforward. Electronic free of charge. Any physical medium, it's a per item cost, 5 and 7 cents, and the cost exceptions, which allows agencies to apply any fees that are set forth in other statutes or regulations. The easiest one I always point to is the accident report statute 39:4-131, which allows an agency to charge up to $5 in administrative costs per accident report if the requester is obtaining the records other than in person. Again, I'll stress other than in person. So any agency, municipal agency that is releasing accident reports, you get to charge up to $5 per report if that person is receiving the report other than in person. And that would apply whether or not the records are being sent electronically, because 39:4-131 does not contemplate the difference between electronic disclosure and physical copy disclosure other than in person. Special service charges. So they still come in their 2 forms, right? The first one being any charge that's associated with duplication of a record that can't be done on ordinary copying equipment. So you have to send it to a third-party vendor. I'm not going to say Kinko's anymore, because then, as if my beard won't show a little bit of my age, Kinko's certainly will. Whether it's FedEx store, if you have to go to Staples to get something copied, you know, those types of costs can be passed on to the extent that you can't do them in-house. And then there's medium conversion. You know, you have a record that requires extensive use of technology and labor costs to convert a document from one medium to another. Then there's the more typical one, which is the extraordinary expenditure of time and effort. So here's what's changed under the amended provision. The charge is calculated and still provided in advance to the requester, as it always has been. But different from before is now the custodian has to include in that response their explanation of an itemized cost of fees and charges. So you can't just say, hey, a custodian, hey, this is going to be $250 special service charge, extraordinary amount of time and effort. Let me know whether or not you're going to accept or reject it. Now it has to be, hey, this is going to be $250. Here's what that charge is comprised of. It'll take us 2.5 hours to do this at this hourly rate, an hour and a half to do this at this hourly rate, and 20 minutes or an hour to do this at this rate. Taken all together, this is what the special service charge is comprised of. We're not really sure where the 14-point analysis is going to fit into this new situation, but we still think it might be useful in trying to develop a special service charge. And it should still, you know, that charge should likely still be calculated based on hourly rates of the lowest paid employees capable of performing the task. You're not going to take somebody who's making, you know, a superintendent salary to basically make copies of a document, right? That could be achieved by someone with, you know, at a lower title at a lower hourly rate. Then it should be calculated based on that. Now, here's the other significant change. If an agency charges a special service charge and the requester wants to challenge that special service charge, the burden now shifts to them, the requester, to prove that that charge is unreasonable. So the statute says that effectively the special service charge shall be presumed reasonable, and that it's up to the requester to prove that it's not reasonable. Now,
Here's the catch. It's going to be pretty clear in a situation where an agency is charging a charge that is astronomically absurd, or that just simply doesn't apply. I think back to the school district who charged a special service charge for 7 minutes worth of work. It was the most impressive calculation for a non-math person I've ever seen. That a municipal clerk, I believe, oh no, it was a school district, that a school district employee broke their salary all the way down from an annual salary into 7 minutes of time. You know, that's going to be pretty easy to basically look at and say, yeah, this is obviously not reasonable or warranted, right? So you want to make sure that whatever that special service charge is, custodians, that it's grounded in factual basis, that, you know, the hourly rates that are there, that you need the time, and that it's an extraordinary amount of time and effort in order to fulfill that request. And then, you know, and then it becomes sort of the requester's responsibility based on the statutory language to now prove that is an unreasonable special service charge. All right, important things to know. Requester has to agree to pay the fee. You can't send them the collection simply because they haven't paid. Special service charges should still be levied on a case-by-case basis. There is no flat rates. We're getting word that there are a lot of agencies passing resolutions and ordinances, especially related to body-worn camera footage, on hourly rates based on review and redaction. That's a dangerous game, because if it starts to look too much like a flat rate, or everybody's adopting the same flat rate, but there's no grounding of each of those rates in actual in actual fact and circumstance of each individual agency, then there's a chance that those resolutions or regulations could end up running agencies into violations of the statute, because the fees are not reasonable and they're not warranted. All right. So the substantial disruption, not a lot of agencies know about this. Not a lot of agencies have used this in the past. In fact, we only have about 2 or 3 decisions. 2 of them are at the bottom. And one of those 2 decisions was a situation where an agency didn't do it right. Notwithstanding, so you receive a voluminous request. And to go back to the validity piece, an invalid request is an invalid request, but a voluminous request is not always necessarily an invalid request. It may just require a lot of work. It may even reach to the level of a substantial disruption of agency operations. So what happens when an agency believes that responding to the OPRA request is effectively going to shut down their operations for a period of time that would be detrimental to the agency? Well, they respond informing the requester of that disruption, but then they also have to work with the requester to try and reach a reasonable accommodation that meets the interest of both parties, right? This isn't necessarily I'm going to look at the request. This request is going to disrupt our operations. It's denied. There has to be a give and take, an attempt to try and reach a solution. Is it extensions? Is it clarifications? Is it special service charges? Is it withdraw the requests and a narrowing of the request on modification? There's a lot of different ways that you can try and accommodate the request. Custodians should keep this in writing, because if ultimately those accommodations fail, then you can deny on the basis of a substantial disruption. And if someone files a complaint, the GRC is going to want to know, well, A, did you advise the requester of the potential disruption? B, what attempts did you make to try and accommodate the request that were going to balance both the requester's need for transparency and the agency's ability to conduct work free from basically total disruption and being shut down for a long period of time simply to respond to the request. Redactions, a denial you can see. That means something very important. That is, don't white out your documents when you're making redactions. We still get it from time to time. I actually was forced to have to do an in-camera review of a particular set of documents on the basis that an agency used whiteout instead of blacking out or some other visually obvious method for redacting the record. Don't white stuff out. I mean, that's the easiest thing I can say. Not much else has changed about redactions. We're still pushing the idea that electronic redaction tools like in Adobe and other PDF and other types of computer programs are great, but certainly manual redaction would also work as well. Either way, you want to make sure that whatever that redaction is not only visually obvious, but that it can't be undone or seen through. So if you're making hard copy redactions, you know, you're blacking out stuff on a piece of paper, don't forget to make a copy to lock that redaction in. If you're sitting at your desk right now and you have a sheet of paper that you can stand to destroy, you know, while you're sitting there at lunch or while you're getting bored of listening to me, go ahead and Sharpie something out and then look at it. And I can guarantee you'll still be able to see what's underneath of there. Making that extra copy is what locks that redaction in. If you're doing electronic redactions, just make sure they can't be reverse. All right, medium format and conversion. So now medium is linked to format, file format. Before it wasn't. As of September of 2024, it now is linked together. So medium meaning electronic to paper, paper to electronic, but also format, WAV to you know, some other type of audio format. I was going to say Winamp, but again, showing my age, my bad. At any rate, now there is an idea of medium and format being the same thing in the statute. The big change here is previously, custodians were required to disclose the record in the medium requested, or if it was not maintained in that medium, some other meaningful medium, meaning meaningful to the requester. Now, the custodian is still required to disclose the record in the medium requested, format requested. However, if the record isn't being maintained in that medium or format, the custodian has an option. The first option is you have to convert the record to the medium requested if it doesn't require substantial work or third-party vendor. So at a minimum, not at a minimum, but one of those options is, hey, I can just real quick turn this, I can scan, you know, this paper in, take me 2 minutes, good, no big deal. It's not going to take a substantial amount of work to do. It's going to be very easy, right? But if there's going to be some substantial work or third-party vendor, right? Then the custodian has the option of disclosing the record in the electronic format maintained at a minimum. So, oh, you know, this record will take a day and a half to convert basically and send over to you, or it'll take several hours and someone's going to be tied up for all that time to convert this record for you. We're just going to give it to you in the electronic format that it's maintained. So this is a little bit different, right? Because before there was kind of the onus to make that conversion, right? And then pass the cost on. Now, what the statute is saying is that effectively, if it's not going to take a lot of work, you should convert it and disclose it in the medium requested. But if it's going to take a whole lot of work to do, then you have to give it in the format that it's maintained at a minimum. The meaningful medium standard is no longer there. It's gone. It's been taken out. And obviously, if there's any special service charges that would apply if you decide to engage in the substantial or third-party vendor work, you know, then you would refer back to the prior slides on special service charge for how, you know, for what those charges would look like. Privacy. So some things have changed, some things have not. There is the addition of some newer, of some more bright line exemptions on privacy. We'll talk about them in the next slide with the new statute, but it doesn't go so far as to completely eliminate the requirement that the courts or the GRC or even the custodians may need to conduct a balancing test in order to determine the disclosability of certain information. You'll see this note right here in the middle. One of the issues that we kept seeing early on in new OPRA was this idea that the definition of personal identifying information meant that custodians can now redact any piece of information that was identified in that definition across the board on any record, no matter what. And that is not true. The definition of personal identifying information in section 1.1 is just a definition. Where that term shows up elsewhere in section 1.1, let's say domestic animal license, personal identifying information contained on domestic animal license, personal identifying information of juveniles under the age of 18, right? Where that term shows up is where the definition can be applied. So this is not a wholesale redaction where agencies can now redact every personal piece of information out there on any record. It's simply a definition that the agency has to look back to and apply where personal identifying information is put into a particular exemption. Hopefully that makes a little bit of sense. But otherwise, there are certain things where we may still have to conduct balancing tests. Home addresses may be a place where we're still going to have to conduct balancing tests. Email addresses in certain situations may be a place where we're still going to have to conduct a balancing test. Let's talk a little bit about a few of those. So we've had debit card and bank account information, which is new. Month and date of birth, or month and day of birth, which is new. Unlisted telephone numbers. I'm sure everyone's very happy about this. No more phone books, no more unlisted telephone numbers. Personal telephone numbers is now the threshold. Personal email addresses, but only where required for government application services or programs. So this is not a wholesale exemption for personal email addresses. This is basically, hey, if you're required to give your personal email address for government applications, services, or programs, then it could be exempt under OPRA. Again, personal information of juveniles under 18. There are very limited exceptions. Portions of the documents containing personal information provided to an agency for official notifications. This one was there before, but it's a little more beefed up. Domestic animal permits. I just basically talked about that moments ago. Then we have the inclusion of HIPAA data and the indecent graphic images. These are all added privacy exemptions that have been placed in the statute. Again, it doesn't go all the way to saying every person's personal information that's making contact with the government is private, but there are a few more than just Social Security numbers and driver's license numbers and credit card numbers and unlisted telephone numbers and Daniel's Law, protected covered person information. There's a little bit more additional privacy protection than in the prior version of the statute. All right, moving on. So dismissal without prejudice. This is a very new portion of the statute. It speaks to what happens when someone files a complaint and the agency turns around and discloses the records that are at issue in that complaint within 7 business days after receiving the complaint. So the Section 6 basically says, hey, if the agency notifies you that they've disclosed the records at issue in the complaint within 7 business days after they receive the complaint, then we're required to dismiss the complaint without prejudice. Without prejudice means that there's a chance that the complaint could be refiled if there's an issue with the records that were disclosed, or if the requester has an issue with the records disclosed. However, it should be noted that a requester may be entitled to attorney's fees if they're represented, and where the custodian knew or should have known that the denial of access violated OPRA. This provision should not be used as a delay or a stall tactic to not provide records to an individual. This is really for situations where there was a genuine mistake. So we go back to the idea of the person said, hey, the question that we had earlier, what happens if a request is missed, or if it gets sent to spam mail, or what happens if the custodian accidentally discloses the record they thought they were disclosing, but it's not the correct record, right? And then a complaint gets filed. For curing sort of actual innocent mistakes like that. This is not for tactical delays in access. And to the attorney's fees piece, if it's pretty clear, this whole knew or should have known the denial of access violated OPRA is a low bar. If the person's represented by an attorney and this situation comes up, and it's clear that the agency basically drug its feet and was like, we'll get to it when we get to it. And, oh, crap, we got a complaint. And, oh, no, wait, we'll just have it dismissed by disclosing the records. There's a good chance that attorney's fees may end up being in the future of that complaint. Now, what I will say is, on top of not using this tactically, the other really important piece here is to know and understand that that complaint could come back. And also, this is not to be used simply because the custodian responded. We've had a couple of times where there's been requests to dismiss the complaint without prejudice simply because the agency responded after the complaint was filed. But that response was them denying access to the OPRA request. This is disclosure of the records that are at issue in the complaint within 7 business days after the complaint was filed. That is when the dismissal would apply. Not simply a response saying, well, hey, we responded, we denied access, this should be dismissed. It's not going to work that way. All right, there have been several questions about the whole harassment situation that I'm aware of coming through the chat. So here's the situation. 5.1 now allows agencies to seek a protective order limiting individuals from submitting OPRA requests if they can prove that the individual was using OPRA with the intent to substantially interrupt the performance of a government function. This is an extremely high standard. This is like knowing and willful level high standard. So, this is going to be a situation where the agency has sufficient proof that the person basically said, I'm going to submit so many OPRA requests, you can't operate anymore. And I'm just going to keep doing it until you get the point, right? The court has a bunch of different options for how to address a protective order, what that protective order may look like. And that protective order is not going to apply, again, to labor unions that are seeking materials for the enforcement of state and federal regulations and statutes on common workplace law topics. So OSHA type issues and stuff like that. So this is a very high bar. And I want, for our custodians out there in the world, the getting to this point where the court is going to issue a protective order is about having sufficient evidence that the requester is operating with the intent to substantially interrupt the performance of government function. And that balance between having that evidence and not having that evidence and what the public fallout could be in a situation where one of these is unsuccessful. That's all part of the equation. And we've seen situations in the past before 5.1 was put into effect, where agencies tried to enjoin requesters from filing OPRA requests. One particularly very public story that ended up going potentially nationwide, we believe, which resulted in not only the agency withdrawing their attempt to enjoin the individual, but also allowed certain other individuals to come in and actually start burying them with OPRA requests. So bad, in fact, that individual, if we're understanding the situation correctly, filed over 200 denial of access complaints with the Government Records Council in an 8-month period back in 2022. Or was it 21? 22. So, there's that public balance between taking away someone's right to transparency because maybe they're being a little vigorous in their submissions, and taking away someone's right to transparency because they're using OPRA in a way it wasn't intended to be used and for malice intent, right? Again, high bar. That's the balance that 5.1 is looking to strike here, is that there is real intent on the part of the requester to basically submit so many OPRA requests that an agency can't function. All right. Everyone here is probably very familiar with the knowing and willful at this point, the knowing and willful penalty, and its civil penalty under Section 11 for violations of the knowing and willful. The big change here with the new statute is that the civil penalty is no longer personal. It's actually identified in Section 11 as payable by the agency. That standard is still high, and the courts may also impose a fine. But as it relates to the shifting of the fee from personal to agency, the agency also has the ability to initiate disciplinary hearings against an individual who has been found to have knowingly and willfully violated OPRA. So this is by no means some type of get out of penalty card for individuals who are not following the Open Public Records Act. The agency, who would have to pay the fine and the taxpayer money that would go out, could turn around and initiate disciplinary proceedings against that individual under Section 11. That means that it may be great that the person thinks that, oh, well, so what? I got a knowing and willful violation. Oh, I'm not paying it. Yeah, but you could end up paying with your job. So this is still a serious penalty. It should be respected as a serious penalty. And even though it's payable by the agency, I'm sure that plenty of agencies out here, if we have any elected officials, if we have any mayors on today, if we have any business administrators on today for municipalities or school districts, are not going to be too happy if they're paying knowing and willful penalties on the part of somebody who simply doesn't want to conform to OPRA. This is still a serious penalty, and it should still be taken seriously. All right, prevailing party attorney's fees. Now, my understanding through all of the hearings that were going on back in the spring of 2024 about PL 24, Chapter 16, was that this was the real flashpoint issue. The idea that Section 6 of OPRA, which awarded attorney's fees to prevailing parties, which was mandatory, is now permissive, right? So meaning there may be situations, and most likely could be situations, where a requester files an OPRA request, they get denied, they hire an attorney, the attorney files a lawsuit either with the courts or the GRC, and they end up prevailing, they get the relief they want, but there's a finding that they're not entitled to prevailing party attorney's fees. I know that was pretty much the shape of the whole conversation when the debates over this particular portion of the statute were going on, again, back in the spring of 24. Here's the situation. That may be the case, but there is a way in which the fee award would become mandatory again. These 3 bullet points here, I direct you immediately to the first one. Unreasonably denies access. That is a very, very low bar. Unreasonable denial of access may apply in a lot of situations, meaning that there's probably more likely than not going to be a significant change. Of course, that's yet to be determined because the courts still have to rule and the GRC still have to rule on individual situations as it relates to prevailing party attorney's fees. But an unreasonable denial of access is certainly a lot lower than acting in bad faith or knowingly and willfully violating OPRA. So, how much this is going to affect the permissive nature of prevailing party attorney's fees is really kind of still up in the air. Now, again, we'll also note that attorney's fees could be awarded in a situation where a complaint is dismissed without prejudice. And it's still the case that non-attorneys, so pro se individuals representing themselves before the GRC or the courts, and attorneys representing themselves. So, Frank Caruso Esquire files an OPRA request about his property and then files a complaint when he gets denied, and is representing himself as an attorney. I am not an attorney, but that's just an example, just to make it clear. Is not eligible for prevailing party attorney's fees. This is only for individuals who are represented by an attorney in an OPRA case, either before the GRC or the courts. And finally, artificial intelligence is here. I don't know how many of our attendees are seeing this. Those of you who may have come to my league session back in November may have seen this slide, have heard me talk about this briefly. Here's the situation. We're getting a lot of submissions lately that clearly are AI generated. And the big issue with that is that the AI generation, whether it's chatbot, whether it's Google, whoever these AI chat programs are, whoever's producing them, what we're seeing is a lot of citations that are completely wrong, that don't exist. A lot of assumptions on what is and isn't legal under the statute that are incorrect. I think that the conversation about providing the reason for an extension of time may have come from AI generated searches and AI generated chats. So from the GRC side, we're really dealing with a lot of complicated issues as it relates to AI and AI generated filings, whether they're complaint filings, whether they're submissions, responses to the SOI. We have not, at least as of yet, fortunately, seen any agencies rely on AI to submit briefs. What I would say is that's probably not the best idea, because again, what we're finding is that there's a lot of anomalies, incorrect information, non-existent case sites, and other information that we're getting as a result of this AI situation. From a requester standpoint, for our requesters who are on today, and really for our custodians, really for anybody, I think it's important to note that AI is never going to be 100% correct. And especially when you're doing a search online, it's going to be based on whatever results are out there. So if you do an AI search about a particular OPRA issue, right? Something like, are dog licenses exempt from disclosure under OPRA, right? That AI generated response is probably going to give you an outdated information based on prior case law. It may give you the correct answer, but it probably won't. So everybody should be careful and skeptical of AI generated responses and AI generated submissions, requesters, custodians alike, because you never know what's being given to you by AI that's going to be incorrect. And what we're finding here at the GRC, especially between me and Mia, who have sort of been going through this now for the past 4 or 5 months, is that a lot of this stuff is coming in very incorrect, very wrong, and it's gonna pose significant problems for our ability to adjudicate the complaints correctly, or I would say more expeditiously, because we're going to have to spend a lot of time checking every individual site in these documents that look like they're AI submitted. It's going to be an issue. So I'm just putting this out there, sounding the alarm for both requesters and custodians alike, to be wary of AI, to be skeptical, to make sure that anything you generate with AI, you're looking through to make sure that it's correct legal sites, correct assertions, whatever the case is, and that you're not being misled by AI generated information. Mia, let's do poll question number 3. All right, the much anticipated poll question number 3, everyone. I have completed my holiday gift shopping. Is that true or is that false? True or false? Again, as I stated with the other 2 questions, go ahead, Mia, and fire up the poll. As I stated with the other 2 questions, if you do not see the poll for any reason, just place your answer in the chat. Whether you don't have permission or it simply doesn't come up, whatever the case is, go ahead and place your answer in the chat, and that we'll be able to track your attendance through that chat, and that will be acceptable. Again, place it in the chat if you don't see it. Oh, there we go. Oh, there it is. I'm curious, in case you're wondering, and I am looking. I'm looking at all these responses to see who's doing their deal.
Frank, you're muted again.
Yeah, it was switching off and on. You got me back, right?
Yes.
Okay, thank you. Sadly, false. Well, I mean, listen, not everybody's an early riser. Seeing a lot of, well, while you're busy all answering in the chat, here's the real answer. Overachievers need not respond unless you're getting credit, in which case you have to respond. Sorry. I'm happy for all the false folks out here because you're in the same boat as me. And that makes me happy. Misery loves company, everyone. Misery loves company. So lots of truths though, and lots of motivation out there for the holidays this year. All right, we'll keep it up for another about 15 or 20 seconds. Then everybody get their answers in. This will conclude the morning session. So what's going to happen from here is we'll have a nice little hour and 15-minute lunch break. We'll actually stop the recording now, though I have a sense that this recording might be a little messy. So we're going to stop the recording. All right.